Hello, my dear friends. I am Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. So, in today's lecture, we will discuss another important maxim of law of tort, that is a Damnum Sine Injuria, which comes under the chapter of Essentials of Tort. As we know very well that for getting a compensation under law of tort, person's legal right must be violated. If his legal right is violated, no doubt, if he has sustained no loss, then also he will get a compensation. But suppose if the person's legal right is not violated and he has suffered a loss, even then he will not get a compensation. So we will discuss damnum sine injuria. It means damage without violation of legal right. So we will discuss certain case laws also in this particular lecture. So let's start the topic. Damnum sine injuria we will discuss in this lecture. So in the previous lecture we have discussed the maxim injuria sine damnum, which means violation of legal right without loss. So exactly the opposite maxim we will discuss in today's lecture, damnum sine injuria. So damnum sine injuria means in case of damnum sine injuria, actual and substantial loss without infringement of any legal right, no action lies. So damnum means damage or loss, sine means without, and injuria means infringement or violation of legal right. So in total, the meaning of maxim damnum sine injuria is loss or damage without violation of legal right. So if the person sustained a loss, but if his legal right is not violated, he cannot file a suit under a tort, and if he file a suit, he will not be succeed, because to claim a compensation under a tort, person's legal right must be violated. If his legal right is not violated, he will not be entitled to get compensation. So for getting a compensation, violation of legal right must be there. So damnum sine injuria says that if the person sustained a loss, no doubt person sustained a loss, but his legal right is not violated, so no action lies. He cannot file a suit before the court of law, and if he file a suit, court will reject the suit. Mere loss in money or money's worth does not of itself constitute a tort. Mere loss doesn't constitute a tort. Only loss will not constitute a tort. For constituting a tort, violation of legal right must be there. So we will understand this particular maxim by a certain example of case laws. Gloucester Grammar School case, that is a particular case dealing with the maxim injuria sine damnum. So in this particular case, plaintiff was running a school and the defendant opens a new school exactly in front of plaintiff's school. So due to the opening of defendant's school, plaintiff has diminished the fee amount, but despite this fact, the admissions in the schools of plaintiff got decreased and the students have taken an admission in the defendant's school. So in this particular scenario, plaintiff sustained a loss due to the opening of defendant's school. So plaintiff filed a suit against the defendant for loss. But in this particular case, court applied the maxim damnum sine injuria, and it was the contention of court, it was the contention of magistrate that defendant was exercising his own legal right, because the opening of school was a legal right of the defendant and defendant was exercising his own legal right, and when the defendant was exercising his own legal right, it will not violate the right of the plaintiff. So court says that here no doubt plaintiff sustained a loss, but his legal right is not violated, hence court decided the case in favor of defendant and court held not liable to the defendant. It means the court decided the case in favor of defendant. Another case law relating to the maxim damnum sine injuria is Bradford Corporation versus Pickles. So in this particular case, this is a particular site of Pickles. This is the particular site of Pickles, and the Bradford wants to purchase this land. But as the Pickles demanded a higher amount of money, the Bradford Corporation purchased a land adjacent to the land of the defendant, Pickles. So the land which is adjacent to the Pickles that have been purchased by the Bradford Corporation. So Pickles, due to that fact, because the Bradford Corporation had not purchased the land of Pickles, Pickles dig a well in his own land, due to which the water in the land of the Bradford Corporation got decreased, and Bradford Corporation sustained a loss, as due to the lack of water there was a loss to the factory of Bradford Corporation. So Bradford Corporation filed a suit against the Pickles defendant, because it was the contention of Bradford Corporation that due to the digging of well by the hands of defendant, I have sustained a loss, because my factory requires a certain amount of water, and due to the decrease of water I have sustained a loss. But in this case also the court applied the maxim Damnum Sine Injuria, and court says that defendant was not liable because the defendant digged a well in his own land. He can do anything in his own land. He cannot encroach in the land of the plaintiff, but he can do anything in his own land. He was exercising his own legal right. No doubt here plaintiff sustained a loss, but his legal right is not violated. For getting a compensation under a tort, person's legal right must be violated. So Damnum Sine Injuria says that though the person sustained a loss, but if his legal right is not violated, he will not get any amount of compensation. So in this case also, defendant was not held liable by applying the maxim Damnum Sine Injuria. Another case, Town Area Committee versus Purbudal. In this particular case, the plaintiff constructed some shop without giving notice to municipal body and without obtaining prior sanction. So the defendant demolished these shops. It means the Town Area Committee demolished the shop of the plaintiff. So here in this particular case, plaintiff constructed some shops without giving a prior notice to the municipal body, as well as he has not obtained a prior sanction from the municipal body. So consequently the municipality demolished these shops. No doubt we knows very well, if we want to construct any shop or if we want to construct any house, we have to obtain a permission from the municipality. If we construct any shop or house without obtaining the sanction, the municipality is having a very right to demolish the land or demolish the house and shop. So in this particular case, municipality has done its own work. Plaintiff filed a suit against the defendant, but here also the case applied the maxim Damnum Sine Injuria, and court says that as the plaintiff himself constructed a shop without obtaining a permission from the municipality, it means the plaintiff's act itself is a wrongful act. So though no doubt he has sustained a loss, but on the other hand, the defendant, Town Area Committee, was exercising their own right. So that's why the Town Area Committee was not liable, because the plaintiff's legal right is not violated in this particular case. So these are the particular cases dealing with the maxim Damnum Sine Injuria. Damnum Sine Injuria means damage or loss without violation of legal right. So I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button, and share this video with your friends. Thank you very much.